let's get on to money.
Okay, go ahead. Because I've already skipped that section. Go back.
There are cases, there are times when the amount, again, you receive in cash is greater than $7,500.
Yep.
And sometimes clients believe if they bring you in $49.95 at a time that they're somehow ensuring that you will accept the cash. That isn't the rule. The rule is quite straightforward. You're not supposed to take cash in aggregate of $7,500, as Nadia has told us. The purpose behind the rule, the way I see it, is they want to ensure that we are not dupes of the client. We're not the ones that are going to be funneling in proceeds of crime or assisting in turning over proceeds of crime. You can take it for fees. Ensure that you make notes as to where the money came from. Ask the appropriate questions, especially with the type of crime that they are charged with. And does it pass the smell test? Does it make sense? Is it common sense that the individual can come with that kind of sum of money? So ensure that you protect yourself.
And just so that it's clear, it's bylaw 9, sub 4, sub 1, if you need to take a look at, because you're lucky enough to get clients that show up with, over $7,500 worth of cash on them. That's the bylaw to take a look at. It's very clear. And if that happened to me, I would probably stick a copy of the bylaw in my file so that when the Law Society came knocking, I can say I've already turned my mind to it. It's in the file. Here are the answers as to where the cash came from. It may seem like a lot to you. I do a lot of Law Society work and I deal with a lot of complaints. And I always say to my client, what's in your file? It's the first place I start. Papering your file. I know we all got into criminal law because there's no paperwork. At least that was one of the reasons I got into it. Then the charter came in and it complicated stuff. But the really important thing is it's your reputation. You need to be able to answer. The Law Society gets more and more complaints because it's becoming, the public's becoming more and more aware that they can complain. So please, I know I sound like a teacher, but really paper your file. Make sure any conversation you have with your client is papered. If you've done something to protect yourself, make a note of it. It will save you later. May it never happen to you, but if it does happen to you, you will remember this day when I'm nagging you and saying, please, please, on behalf of your counsel who may be assisting you, make sure your file is papered.
And that goes for everything. When you meet with your clients, ensure that you properly make notes. When there's phone calls from them, try to make notes. Ensure that your instructions, wherever possible, are written. Follow up with letters. Answer your emails. And how about when you're meeting with the Crowns?
Well, when you're meeting with the Crowns, I mean, one of the things to always remember is I have been advised by my client. Unless you know something yourself, but the information's coming from your client or another party, I am advised.
Yeah, don't bring out that stamp of certification for your client. It's your reputation that's going to last your entire career.
One of the other areas I see a lot of complaints are when a lawyer who does a lot of criminal law decides they're going to suddenly do a real estate deal for their favorite client. It happens to be a client who previously had a couple of convictions for fraud, but it's a mortgage, it's something different, it's the family home. Don't dabble in other areas, it would be my advice, unless you're going to get into it and actually look at the law and spend some time on it. But when a client's pushing you to do something that you've never done before and to give advice in an area, refer it out, because you don't need the problems of having to spend time and money on responding to the complaint later on or the allegations that you've assisted in a fraudulent mortgage transaction.
Much easier if you're practicing criminal law full-time to go onto the LawPro site and click the exemption waiver.
Yeah.
Stick to practicing criminal law.
Domestics within the is another area I find that we can be pushed. If you're representing a complainant, sometimes I feel that I'm being used to try to get a certain position to advance a family law position. Ask questions, again, make sure that you've got clear notes.
Determine where your retainer's from too.
Yeah. The other issue, determine where your retainer comes from, was his comment. The other issue is when your client comes in and says, oh, don't worry, the complainant's on side, just call her. Tell her, it's okay. Here's her number. Well, take a look at the bail conditions first and foremost. Secondly, her number may not he may be using the number to intimidate her because suddenly a lawyer's calling on his behalf. That may be intimidation. Be very careful when you're contacting a complainant. If you're going to do that, try to have someone present in the room when you're making the phone call. And if you can't have someone present in the room, make notes.
Be careful. You won't be the first one that's been charged.
Another thing that the Law Society sees a lot of complaints are on affidavits. You know what, can you prepare this affidavit? Don't worry, I'll sign it later, and then you can just commission it. Commissioning an affidavit after the fact is misconduct. Do not do it. It's a piece of paper. Take the time. It may, you know, I've known this client for 10 years. I'm sure he'll have signed it, and no big deal. Well, if it turns out that the signature is not his because he was too busy to sign it, it will be a big deal when you're meeting your regulator.
Okay, do you continue to represent someone when you believe that you're becoming a tool?
The rules require that if you have any reasonable belief that you are being used as a dupe, to withdraw. Again, I would seek the advice of senior counsel, and again, I would memo my file, and I would ask to be removed from the record. You can indicate it's a breakdown of the solicitor-client relationship, which is what it is. You are not to breach the rules of confidentiality by saying, because he made me sign an affidavit which he hadn't signed. You don't need to get into the whys, but you can indicate I've consulted with senior counsel. I've confirmed there is in fact a breakdown in the solicitor-client privilege. Gone.
Do you report them to the police? You have either the bounce check, the phony check, the counterfeit money, and the list can go on.
There's debate on that one. It's not a clean answer.
When it's not a clean answer, what's the best advice?
The best advice, again, I seek the advice of senior counsel, and I usually will go to 1 or 2 different lawyers and speak to them. And again, if I decide that I'm going to do that, I would have senior counsel go with me, perhaps, to give that information. I can tell you the one place that is very clear in the rules that you can actually say my clients have put a bomb in the courtroom. There is actually a provision where the security of the courthouse is at issue because of your client's actions, and you have that information. You're obliged to give the particulars of that under the rules of professional conduct. But otherwise, it's really a sticky area as to, do you actually say my client's a fraud artist and he just did this to me? You become a complainant because of your solicitor-client privileged relationship. I personally don't know that I would do it, but it all depends on the facts and the circumstances, and it's a difficult question to answer in a very general way. Another thing that I will tell you that the Law Society will do, legal aid. If you're suspended, but you're providing bills in which you're actually acting in court in a period when you're suspended, that's a form of fraud. You can be charged with professional you could have an allegation of professional misconduct made against you. Legal aid does keep that information and does share it with the Law Society. So it's important that even if your client's urging you, look, you promised me you would be at my trial and you're suspended, do not practice. The courts are also provided with lists of suspended lawyers. Do not practice.
Judge's report.
Finally, with respect to if you find that you are in a situation that you have been a dupe or that your clients have been acting in a manner that has that has compromised you, you do have the obligation to withdraw. And I would also recommend that you consider your obligations with respect to Law Pro and whether you need to self-report to the Law Society. And again, just carefully read through the rules and speak to someone more senior or to a colleague and make sure you've had a conversation with someone over that.
4 simple rules when you find yourself in a situation where your client is being dishonest or trying to dupe you. Number 1, memo the file. Number 2, seek advice of senior counsel. Number 3, seek to remove yourself. But you be careful on what you say on the record, because you do owe a duty of confidentiality to the client. And number 4, always...
Sorry, I wrote number 4. It's actually not relevant to that.
It's okay. Number 4, take a look at the rules, know your rules, protect yourself, enjoy your career. Tried to fill up the 30 minutes. We may have gone over by a few. Thank you very much, Nadia Levi. I really want to thank you. Nadia came out last year and helped us out. We had wonderful reviews, great accolades for her. I appreciate her coming out again, and so I'm going to call on you on October 20th if I can again. Thank you.
Thanks.